Yes.
All right, good afternoon, everybody. We'll go ahead and get started. For those of you who don't know me, I am Michael Sharp, the interim dean here at Case Western Reserve University School of Law, and also the director of its International Law Center, the Cox Center. And we have had a wonderful semester of events, and I see many people in the audience that we've had at our other events. This is our last event of the semester. It seems like it's gone by really quickly, but I feel like we've saved the best for last in a lot of ways. If you've been here all semester, it kicked off with a huge international conference about high-tech weaponry and super soldiers, so something a little bit outside the ordinary. We've had panels on the Foreign Corrupt Practices Act. We had Mark Ellis, the Executive Director of the International Bar Association, launch publicly for the first time ever his new app that will be used to record evidence of war crimes around the world. And we're going to end with a really, really special lecture by Judge Mark Barnett. Professor Juscelino Colares is going to introduce you to Mark, but I will say what makes this particularly special for me is that I've known some people for a long time. Yes, I'm getting a little gray. I knew, for example, Madeleine Albright when she was just a professor, and Samantha Power, who's spoken here when she was just a journalist. But Mark I've known perhaps the longest. In college, we ran the National High School Model UN Conference together. I was the Secretary General, he was the Undersecretary General. We had 50 college students that were our staff and 2,000 high school students at the real UN portraying the United Nations. And I think both of us would say that our careers in international law and our love for international law was launched way back then. And it's such a treat to have a friend from that long that has now become a judge of the U.S. Court of International Trade. And please join me first in welcoming Juscelino Colares, who will give you the biographical information to introduce Judge Barnett.
Thank you all for being here. Again, my name is Juscelino Colares. I teach here at Case. I've been here for 3 years. I teach international trade law and a bunch of other courses, but it's very rare that as an academic former prior who's had some years of practice in DC in the trade area, that you actually meet experts that are as qualified as Mark, as Judge Barnett, sort of. As Judge Barnett. He's graduated with very high honors from Dickinson College, Michigan Law School, and he went from that to a career as a lawyer at Steptoe and Johnson, one of the best trade firms in DC, which I appear often against in my own days.
In connection with my coming out here today. And so I appreciated that chance to get to learn a little more about him and his career. And it was all as a result of my agreeing to come speak with you today. So I really do appreciate that. Got to spend a little bit of time this afternoon wandering about University Circle and some of the campus buildings here. And I love the architecture, and I'm sure he would be very impressed if he were to come see it all today. So thank you again for this opportunity. Let me start off by giving you a little bit of background, first on myself, and then about the court on which I sit. Primarily to give you a sense of the experience that informs my perspective on the interplay of international obligations with domestic law. Prior to being appointed to the bench, as Professor Colares told you, I spent 18 years in the General Counsel's office at the U.S. Department of Commerce. And for the last 8 years there, I was the Deputy Chief Counsel for Import Administration. In that role, along with the Chief Counsel and a staff of roughly 30 attorneys, we provided legal advice to what was then called Import Administration. It's the agency within the Department of Commerce that's responsible for administering the U.S. unfair trade laws. In other words, the anti-dumping and countervailing duty laws. As the attorneys for Import Administration, we advise the agency on all aspects of its anti-dumping and countervailing duty determinations, participating as members of Import Administration's team, along with analysts, accountants, policy advisors, and others as they conducted their investigations and other administrative proceedings, and we reviewed their determinations for legal sufficiency. Those determinations could then be challenged in several different fora, sometimes simultaneously. Within the U.S. legal system, any party that was involved in the administrative proceeding could challenge the determination before the Court of International Trade, on which I now sit. Attorneys from Commerce would work closely with the Department of Justice attorneys to defend the agency's determinations, drafting briefs, and preparing the DOJ attorneys for oral arguments. If the case involved imports from Canada or Mexico, parties have the option of taking their case to a binational panel composed pursuant to Chapter 19 of the NAFTA instead of the Court of International Trade. And these NAFTA panels are ad hoc panels of experts, practitioners, and academics composed for hearing the individual case. By the terms of the NAFTA agreement, these panels apply the domestic law of the country in which the determination was made. In these cases, Commerce has its own litigating authority, and their attorneys draft and file the briefs, and they make the oral arguments directly to the binational panels. In addition to these challenges under domestic law, the government of the exporting country may elect to challenge Commerce's determination or its practice, its regulation, or even the statute before a dispute settlement panel at the World Trade Organization, with, of course, the possibility of an appeal to the WTO's appellate body. In these cases, the Commerce attorneys work side by side with attorneys from the U.S. Trade Representative's office, drafting the written submissions and arguing the cases in Geneva. I should note that in addition to providing legal advice during the administrative proceedings and defending the determinations in litigation, Commerce attorneys also work closely with senior officials in the client office in international negotiations. So whether it's a case-specific suspension agreement, as was recently announced, for example, in the sugar dispute with Mexico, free trade agreement negotiations, such as the ongoing Trans-Pacific Partnership, or TPP, and Transatlantic Trade and Investment Partnership, or TTIP, that we're negotiating with Europe, or the WTO's Doha round of negotiations to revise, among other things, the anti-dumping agreement and the subsidies and countervailing measures agreement. In these roles, I was fortunate enough to be able to combine my legal and litigation experience with my understanding of the policy concerns that the exhaustion of administrative remedies in order to challenge some aspect of Commerce's determination before our court. No such requirement exists at the WTO. Similarly, while the Court of International Trade typically disregards post hoc reasoning that's offered in litigation, where that reasoning cannot be traced back to the agency determination itself. Again, there's no similar practice in WTO dispute settlement. Consequently, neither the individual party that's appearing before Commerce nor Commerce itself has any need to preview any of its WTO arguments during the administrative proceeding. Now, a party may also seek to raise a WTO argument before a domestic court or an NAFTA panel. And as I noted in my introduction, when reviewing Commerce determinations, NAFTA panels are required to apply U.S. law by the terms of Article 1904 of the NAFTA. That provision requires the panel to determine whether the anti-dumping or countervailing duty determination is in accordance with the anti-dumping or countervailing duty law of the importing party. It goes on to say, and I'll quote, "For this purpose, the anti-dumping or countervailing duty law consists of the relevant statutes, legislative history, regulations, administrative practice, and judicial precedents to the extent that a court of the importing party would rely on such materials in reviewing a final determination of the competent investigating authority," close quote. Thus, when a NAFTA panel reviews a determination by Commerce, it stands in place of the U.S. court and must apply U.S. law. That's why I've grouped NAFTA panel review with review that they have to have an independent authority under domestic law in order to make that kind of an alteration. We may be able to draw some useful parallels between this situation and the one the Supreme Court looked at in the Medellin v. Texas case in 2008. Okay? There, the court looked at the Vienna Convention on Consular Relations, along with a decision from the International Court of Justice. While that international agreement was a treaty, and it was ratified by the United States, the court found that neither the Vienna Convention nor the decision of the ICJ were self-executing. In fact, it considered that the United Nations Charter provides that members undertake to comply with the ICJ decision in any case in which it's a party, signaling the need to take some action in the future, and that recourse in the case of non-compliance is to the UN Security Council, where they noted that the U.S. holds a veto. The combination of these factors made it clear to the majority of the Supreme Court that compliance with the decision of the ICJ was a matter for the political branches in the exercise of their foreign relations powers, and not one that should be enforced by the domestic courts. While the United States doesn't hold anything close to a veto at the WTO, dispute settlement reports typically ask a party to bring their measure into conformity with the WTO agreement, a similar signaling of future action. The dispute settlement understanding, the agreement that covers the dispute settlement system at the WTO, also contains provisions relating to the possibility of providing compensation rather than implementation, and for the possibility of retaliation in the event of non-compliance. Similar to the situation examined in the Medellin case, I'd suggest that these provisions provide a similar indication that compliance with adverse WTO decisions also is within the realm of the political branches and should not be enforced by the judicial branch. While parties may accept that the WTO agreements, as well as panel and appellate body reports, do not have direct effect in the United States, that's not stopped them from arguing that WTO agreements and panel or appellate body reports interpreting those agreements should be used by the courts to construe U.S. law that's ambiguous. And the authority cited for this proposition dates back to an 1804 Supreme Court case called Murray v. the schooner Charming Betsy. Therein, the court held that an act of Congress ought never to be construed to violate the law of nations if any other possible construction remains. This is consistent with current restatement third of the Foreign Relations Law of the United States, which recognizes that while international obligations cannot override inconsistent requirements of domestic law, ambiguous statutory provisions should be construed, where possible, to be consistent with international obligations of the United States. So the argument is that when commerce has interpreted an ambiguous provision of the anti-dumping or countervailing duty statutes in a way that's inconsistent with our WTO obligations, as determined by a dispute settlement panel or the appellate body, domestic courts should apply the Charming Betsy doctrine to require commerce to revise its interpretation to be consistent with that dispute settlement interpretation. Now, there have been several responses offered to a Charming Betsy argument, some successful and others, at least directly speaking, less so. First among the possible defenses is that the statutory provision in question is not ambiguous. Congress has clearly spoken on the issue, and the statute's not ambiguous, then the Charming Betsy doctrine cannot come into play. In such a case, domestic law prevails, and the contrary findings of the WTO dispute settlement system must be resolved by congressional action and not the courts. A second argument that's been made in unfair trade cases is that reliance on the Charming Betsy doctrine by private parties has been foreclosed by statute. Section 3512 of Title 19 of the U.S. Code provides that only the United States shall have a cause of action under any of the WTO agreements or by virtue of congressional approval of the WTO agreements. Moreover, no private party may challenge an agency action as inconsistent with the WTO agreement. Generally, the courts have been reluctant to rely on this provision to decline jurisdiction over a challenge to an agency determination in the unfair trade area. In rejecting this argument, what they found is that the party's claim is being made under the domestic statute, In other words, it's a claim that's essentially a Chevron prong 2 type claim, as you probably learned about in administrative law, that the agency's interpretation is unreasonable because it leads to this inconsistency. You might consider that to be a fine distinction, but that's where the line's been drawn. Now, let me insert a side note here. Section 3512, to which I made reference, is definitely one-sided. It prohibits private parties from making claims based on WTO agreements. But it doesn't prevent the United States from relying on the WTO agreements, and to that extent, even relying on the Charming Betsy doctrine. This is especially important when an agency takes action in order to implement an adverse WTO decision. And I'll talk about that process in just a minute. But when it does so, the agency must explain the reasoning for its change in interpretation of the domestic law. And in that case, it may rely on its stated goal of compliance with the WTO dispute settlement decision. To this end, in my previous career at Commerce, I've argued that while Charming Betsy cannot be used as a sword by private parties to force compliance by the United States, it can be used by the United States as a shield to defend their change in interpretation of the statute. A third argument that's been raised is that WTO panel and appellate body reports do not constitute the law of nations within the meaning of the Charming Betsy doctrine. Article 3.2 of the Dispute Settlement Understanding states that the dispute settlement system is meant to clarify the existing provisions of the covered agreements in accordance with customary rules of interpretation of public international law. In the earliest days of the dispute settlement system, the appellate body stated that because the purpose of the DSU is to settle the particular dispute between members, quote, we do not consider that Article 3.2 of the DSU is meant to encourage either panels or the appellate body to make law by clarifying existing provisions of the WTO agreement outside the context of resolving a particular dispute. Consistent with that, Article 9.2 of the Marrakesh Agreement that created the World Trade Organization sets forth that the Ministerial Conference and the General Council of the WTO have the exclusive authority to adopt interpretations of the WTO agreements. And Article 3.9 of the DSU reconciles the dispute settlement system with Article 9 of the Marrakesh Agreement, providing that the provisions of the DSU are without prejudice to the right of a WTO member to seek an authoritative interpretation from the Ministerial Conference or the General Council. In short, a dispute settlement report only resolves the issue before the panel and as between the parties before the panel. Only the Ministerial Conference or General Council can offer a broader binding interpretation. Accordingly, dispute settlement reports not involving the United States as a party do not create implementation obligations on the part of the United States. And the United States is under no obligation to alter its laws or methodologies in response to such WTO dispute settlement reports. Without such broader applicability, it's difficult to argue that such reports constitute the law of nations. It's also difficult to make the case that dispute settlement reports represent the law of nations when the terms of the dispute settlement understanding recognize alternatives to implementation. In fact, as I mentioned earlier, a WTO member country may choose to respond to a panel or appellate body report without changing the measure found to be inconsistent with the WTO agreements. To that end, the dispute settlement understanding provides for alternative resolutions, including the provision of trade compensation and other negotiated settlements, or the suspension of benefits equivalent to the nullification or impairment of benefits caused by the offending measure. To return to the analogy I drew earlier with the Supreme Court's decision in Medellin, the structure of the dispute settlement understanding, like the structure of the UN Charter, makes it clear that implementation, or the manner in which non-implementation is addressed, are issues that should be decided by the political branches, not the judicial branch. Finally, let me return to that issue of ambiguity in the statute and address it from a slightly different angle. And I said earlier that one argument that might be made against the application of Charming Betsy was that the statutory provision in question was not ambiguous. Well, let's accept for the moment that the substantive provision at issue is ambiguous. Okay? But let's also say that in an abundance of, I might even call it precognition, Congress anticipated the situation in which a WTO dispute settlement report find an agency's discretionary interpretation or application of a statute to be WTO inconsistent, and that Congress laid out a non-ambiguous procedure for addressing that finding, including provisions that clearly leave the executive branch with the discretion not to come into compliance. That's in fact the situation that we have in the unfair trade area. With respect to the anti-dumping and countervailing duty matters, Congress provided two procedures by which the United States could come into compliance with an adverse WTO report. Regardless of which option we're talking about, compliance is only possible when it would be consistent with existing law. As I said earlier, if the anti-dumping or countervailing duty statutes require the WTO inconsistent action, it's up to Congress to take the necessary action to come into compliance. So the first method for implementation was set out in Section 123 of the Uruguay Round Agreements Act. Now, 19 U.S.C. Section 3533. It creates a procedure to amend, rescind, or modify an agency regulation or practice that's found to be inconsistent with the WTO agreement. That change, however, cannot occur unless and until an elaborate consultation process has been undertaken. The steps include the U.S. Trade Representative's Office and Commerce consulting with the appropriate congressional committees, along with private sector advisory committees, and providing an opportunity for public comment, all before determining whether and how to implement the WTO report. No implementation can become effective until the relevant congressional committees have also been given time to indicate their agreement or disagreement with the proposed implementation. The second method for implementation was set out in Section 129 of the URAA, now 19 U.S.C. Section 3538. This process is narrower in scope, and it applies to the situation in which a dispute settlement report finds that a particular action or determination by Commerce was not in conformity with U.S. WTO obligations. Like the earlier procedure, this one requires USTR and Commerce to consult with the relevant stakeholders before USTR determines whether to request Commerce to issue a new determination not inconsistent with the WTO report. Again, that's a discretionary determination by USTR. Moreover, even after Commerce issues a new determination that's not inconsistent with the WTO report, the statute provides that USTR may direct Commerce to implement the determination, and it may do so in whole or in part. And this is where it gets fun, for some of us at least. These so-called Section 129 determinations, if USTR directs Commerce to implement them, they can be challenged in domestic court. That challenge in domestic court is only to ask whether the determination, this 129 determination, is based on substantial evidence and is otherwise in accordance with law. In other words, with U.S. law, just like any other Commerce determination. What makes it interesting is that Commerce's original determination may still be under review by the courts at the same time the Section 129 determination is being challenged. This is possible because the 129 determination only has prospective effect. So the original determination still covers imports made between the time of that original determination and the Section 129 determination. And the 129 determination governs into the future. The statement of administrative action refers to such a scenario, stating that, and I'll quote, "In such situations, the administration expects that courts and binational panels will be sensitive to the fact that the applicable standard of review, as set forth in statute and case law, Multiple permissible interpretations of the law and facts may be legally permissible in any particular case, and the issuance of a different determination under Section 129 does not signify that the initial determination, and I'll put it in brackets, that was found to be WTO inconsistent was unlawful. So how's that for a punchline in the area of the unfair trade laws, at least? Congress and the administration have pretty much put the schooner Charming Betsy to rest at the bottom of the sea. So what's the takeaway from all this? Well, I'd suggest that the takeaway is that the unfair trade laws provide a helpful, or at least an interesting, maybe, case study if you face questions about the relevance of international law in a domestic setting. They can certainly be helpful to you in identifying questions to ask, analytical approaches to take, regardless of the field of law in which you're considering the issue. If your career takes you to Capitol Hill or the executive branch, in some position where you might be developing, implementing legislation relating to pretty much any kind of international agreement, regardless of whether it relates to the environment, human rights, terrorism, or any other field of law, there's lessons to be learned from here in terms of the scenarios that you might want to anticipate and account for so that you can make clear what happens when the inevitable conflicts arise between the implementing legislation and the international treaty, agreement, or law that you're seeking to implement. Thank you again for the kind invitation to come speak here today, and I look forward to taking some questions. Thanks.
Thank you, Mark. Thank you very much for your remarks, Judge Barnett. We have 22 minutes. We would very much like to welcome questions to you. I would like to start with one observation and one quick question. The observation is all my students in my international trade law class who are here, you should thank Judge Barnett for giving you the perfect outline response to outline to my international trade law course. And you should all be glad that I start with U.S. trade law and not WTO law. Now, my question, Judge Barnett, and it's directed more to the former United States Department of Commerce official than to the judge, because the questions of law are pretty much settled. But I refer back to the Mark Barnett, who used to work at the Department of Commerce, especially because of his interactions with the United States, with the WTO appellate body and WTO panels. And the question is a simple one, rather. If U.S. trade courts, the Court of International Trade, in which you now sit, and the Court of Appeals for the Federal Circuit, tend to review U.S. trade remedy determinations, anti-dumping and countervailing duty law determinations. And they tend to uphold these agencies' decisions by about 2/3 or upwards to 2/3 of the time. Why do you believe that NAFTA Chapter 19 panels, who have the same jurisdiction, tend to reverse U.S. Agency decisions on the same law, applying or supposedly applying the same principles of administrative review of trade determinations at twice the rate? Meaning, U.S. courts tend to reverse Commerce and International Trade Commission decisions only 32% of the time. NAFTA tends to reverse, NAFTA panels tend to reverse U.S. Department of Commerce and International Trade Commission 68% of the time. And why do you think that the same phenomenon seems to occur at the WTO panels and appellate body, but not even at that rate, at the rate of around 90%? Thank you.
Interesting question. I think my first response is, I haven't read your article yet, so I don't know the right answer to provide. But, I mean, I'd offer a couple of...
Is it because you judges in the United States are biased?
Of course not. Of course not. No, I think probably a couple of different answers. I mean, depending on the group of cases you might be talking about. I mean, I think One option is there's certainly some interest, there's some reality to the fact that in some cases, panelists tend to vote the flag. And I don't want to overstate that. I mean, I start off with that because we were talking for a while beforehand today. We were talking about, one of the reasons, the biggest reason that Chapter 19 exists in NAFTA, I don't think anybody truly believes is because the Canadians thought that U.S. courts couldn't give an unbiased review of unfair trade cases. Because of lumber, one product, one big case, lots and lots and lots of money. I mean, we're talking billions of dollars at stake. I mean, you could pretty much add up, I suspect, all the other unfair trade cases that the United States has, and maybe they start to come close to what lumber's worth in terms of import value and duties that we had when the lumber cases, the lumber orders were in effect for a little while. So that's a huge interest for Canada. And I think if you look back and you separate out the lumber decisions, the lumber panel reports, I think you're going to be hard-pressed to find a Canadian panelist who votes against Canada. But let's put that one aside, because I think I don't want to be unfair to Canadian panelists or any other NAFTA panelists, because I think for the most part, outside of that one context, I think NAFTA panelists generally do a fairly decent job. That was our take on it at Commerce. To the extent that they are a little more, well, let's put it this way, a little less forgiving of the agencies, I suspect that's probably in the nature of who you have as panelists. And I don't mean this in a negative way. It's just you have ad hoc panels of experts, very often practitioners. These are folks that have argued before these agencies on one side or the other, whether representing U.S. domestic parties or Canadian parties or Mexican parties, as the case may be. And so they've probably been a little bit frustrated by the kinds of issues that they may be dealing with. I mean, I'm not suggesting they've got a direct conflict in terms of the issue that they're addressing, but they've been faced with Commerce decisions finding that, oh, you didn't give us a good enough response, and now we're going to make this adverse inference against your client, and they're going to get this really bad decision out of Commerce. And so there's probably some interest there in pushing the agency to do a little better job, maybe be a little bit more forgiving in those kinds of situations. And so I think the expectations that they come in with are probably higher than what some of us who have the benefit of sort of a lifetime appointment come to expect from the agencies and come to expect in our review of agency determinations. But that's my guess, and I look forward to reading your article and finding out the right answer. Sure.
You do a great job, I think, of outlining the ways in which Congress apparently... Thank you. Thank you again also very much for the presentation. It's a model of clarity in a very murky field. You do a great job of explaining how this is one rare instance of Congress thinking through very clearly and consequentially exactly how to respond and treat applicable law. Right? And so my question goes to sort of the second level, which is, so beyond applicable law, could you elaborate a little bit on your view of how well they treated the issue of sources of interpretation and how strongly they limited the sources of interpretation that agencies could use in determining nature, scope of particular terms of art within that framework? Did they do a similar job of being fairly limiting, or did they allow reference to things like the U.S. position in the negotiations during the round and things like that?
I was with you, I think, until the very end, and that is, let me say, they don't. The answer to your question is, I don't think they're very limiting in general. As a domestic judge, the standard of review that we apply to, for example, most of these agency determinations is a standard, not quite APA standard of review, whether there's substantial evidence on the record and whether the decision is otherwise in accordance with law. We apply Chevron all the time. And like I said, most of the decisions focus then on substantial evidence. There's not a lot more development of that standard than that in terms of looking at other sources of law, if you will. It's very much the practice of administrative law with the umbrella of international hanging over it. But otherwise, it's really review on an agency record that's sent up to us in most of these cases. So, I mean, something like the U.S. position in the negotiations, it may be of maybe of interest to us in an academic sense, if you will, but I think it's rare that it comes into play in our decision-making process. I mean, I will say there have been some judges, including some who were on the Court of Appeals for the Federal Circuit, who would talk a little more openly about, well, should we, since we're a specialized court in this area, be trying to think a little more about harmonizing U.S. law with our international obligations. And I mean, I wouldn't necessarily subscribe to that position, because I think Congress has laid out what our role is in the statute establishing a court and establishing our standard of review. And as I think for all the reasons that I said here today, I don't know that the decision-making process in Geneva is necessarily something that should come to play in our interpretation of domestic law. Sure. Oh, sorry, we got. Maybe I'll come back to you since the microphone is in the back there. Okay.
What issues do you predict the Court of International Trade will be facing now that the DOC has published its notice that it will be eliminating the zeroing methodology in order to comply with WTO regulations? Like, what do you think one of the main issues will be?
Well, zeroing is going to continue to be an issue, frankly, and that's going to be one of them. And the reason I say that is, I mean, what Commerce has done so far is back in, 2006, 2007, they said, all right, in investigations where we use this one comparison methodology, we're going to stop zeroing. And then they said a few other things about other comparison methodologies, but that doesn't really come into play. Then after a couple of additional WTO decisions, they came out somewhat recently, about a couple of years ago, and said, in administrative reviews, we're generally going to stop zeroing. And we have a default position that we're going to use an average-to-average comparison methodology and not zero. Let me pause for a second, because I don't want to assume that all of you know what I'm talking about, and you may be looking at me thinking, what is he talking about in terms of zeroing? So the 30-second explanation of what zeroing is we talk about dumping cases on particular products. Well, a dumping case on a product isn't a very specific thing. So I mentioned lumber, okay, Canadian lumber. So we had an order on the dumping of softwood lumber from Canada. Well, all lumber is not the same. And so when you do price comparisons on lumber, you look at U.S. sales of 2x4s, compare it to Canadian sales of 2x4s. You look at U.S. sales of 6x6s, compare it to Canadian sales of 6x6s. Okay, you make all those different comparisons. Well, maybe what you find out when you make those comparisons is the 2x4s were dumped. They were sold in the United States too cheaply. They were sold for less than what they're sold for in Canada, and overall, the U.S. industry is being hurt. The 6x6s, on the other hand, were sold for whatever reason at a higher price than normal value. The U.S. importer was paying more for those than what they would otherwise pay for them in Canada. The question is, when you put all that together, how do you do it? Do you just focus on the dumping that occurred with regard to the 2x4s and maybe spread that out over all the imports of lumber? Or do you actually reduce that amount of dumping that you found on the 2x4s to account for the amount by which the 6x6s were sold at higher prices? Do you provide an offset in that case? The U.S. practice forever has been no offset. That's it. We just take the amount of dumping, in this case, let's say on the 2x4s, and then the denominator in that calculation is all lumber. so that we spread that out over everything, and the amount of dumping duties we collect would just get us to the amount by which the 2x4s were dumped. Okay? That became known as zeroing because what other countries argued, they got to name it because they came out and made the arguments first. If we had named it, we probably would have called it offsetting. We might have had better success if we had named it and named it offsetting. They called it zeroing, though. They said what you're doing is you're taking that negative dumping margin and you're changing it. You're resetting it to zero, zeroing, before you combine it all. And because you're changing it, that's wrong. Okay? Nobody agreed to get rid of zeroing, U.S. position. Nobody agreed to get rid of zeroing in the Uruguay round. Everybody who was really involved in negotiating it, not just the United States, Europe, Canada, Australia, everybody who had an active anti-dumping practice all did zeroing, okay, even after the WTO agreement. And despite the fact that in other areas where they made big changes in the WTO, everybody made the changes to implement those changes in the agreement. So they put in this sunset provision. Said, okay, used to be an order could live more or less forever. Now, with the WTO agreement, they said every 5 years you've got to review it. Nobody pretended that that didn't exist. Okay? They all faithfully implemented that. The only thing that, according to the appellate body, nobody faithfully implemented was this ban on zeroing. In any case, to get back to the question, now that we have a sense of what zeroing is, it's hard to answer it very precisely because then it gets into, you get into comparison methodologies, you get into the stage of the proceeding. Commerce has gotten rid of it with one comparison methodology in investigations. They've gone as a default to a different comparison methodology in reviews where they've agreed not to use zeroing. But they have strengthened their practice with regard to what's called targeted dumping, where you might see a pattern of prices by customer, by region, or by time period in the United States that gives a sense that, well, maybe there's something a little fishy going on here. And in that case, instead of aggregating everything in these broad averages, we're going to disaggregate all the U.S. prices and we're going to look at it transaction by transaction whether dumping has occurred. And in those cases, a lot of folks, a lot of panels, WTO panels have even agreed that it only makes sense to do zeroing because if you don't, think about it, mathematically, you end up as if you're just doing average to average comparisons and providing that offset. So we're still zeroing in the targeted dumping context. That targeted dumping test has been changing, evolving over the last few years. They've just rolled out a new one within the last year and a half, 2 years, thereabouts. The parameters of that are going to continue to be explored. I think it's Korea in their WTO challenge for either washers or the refrigerators determination is they're challenging at the WTO our targeted dumping methodology in investigations. So zeroing is going to continue to play out. What are the other big issue? The other big issue, frankly, is going to be China. Continues to be China. In the countervailing duty context, in subsidies, you can countervail. Didn't talk about subsidies at all. But you can countervail subsidies where they provide a benefit. There's a financial contribution that provides a benefit, and it's specific to whether it's based on region, industry, company, et cetera. For the longest time, the approach of the United States was in the context of a non-market economy, like the Soviet Union, China, et cetera. The concept of a subsidy can't really exist. You've got a centrally planned economy. The fact that they're directing resources to one industry over another doesn't really make any sense. It was affirmed back in the 1980s in Georgetown Steel that you didn't apply the countervailing duty law to non-market economies. In 2006, Commerce changed its position with regard to China. They said, we think China, it's not really an on or off switch. They've evolved enough that at least while we still consider them a non-market economy, the concept of a subsidy has meaning within China, and they started applying the countervailing duty law. Number of cases in that area, how that's gone back and forth, and now, while Congress has confirmed the ability to use the countervailing duty law with regard to China, they've also provided that there's a demonstration that applying both the anti-dumping law and the countervailing duty law constitutes sort of a double remedy, overcounting, if you will, that Commerce should make an adjustment for that. Well, this is, again, it all comes down to money, because every dollar you don't adjust for is an extra dollar that's collected at the border in a duty. So that methodology, as it's going to continue to be developed, is going to be fought over tooth and nail, because that's where all the cases are. You know, I took a look, I think 97 out of about 250 anti-dumping cases are against China. 27 out of 52, I think it is, countervailing duty cases are against China. We've got about 300 orders, almost half of them are against China. That's where the money's going to be, and that's where the fights are going to be, and that's where the issues are going to be, I think, going forward to a large degree. Sorry, that was a long answer to a straightforward question.
But it's perfect as to my question, which is on double remedies. And in the context of a customs penalty, a gross negligence or negligence penalty case, where the penalty is typically a multiple of the loss of duties, the unpaid duties or underpaid duties. Are you aware of, or can you perhaps comment on what type of reception the court might give to an argument that an inconsistency with WTO obligations, which I believe double remedies has been determined as such, may be a mitigating factor in a penalty case?
I mean, I'm not aware of any decision that's addressed that, and so, I mean, I certainly wouldn't want to be prejudging anything in terms of where it goes. I mean, I will say, I'm not sure, you may be using sort of the concept of a double remedy and sort of, and maybe sort of combining two things together that don't really belong together, because at least in terms of the double remedy in the context of the application of anti-dumping and countervailing duty law, that's a specific issue that arises because of the non-market economy methodology that applies to China. And it's only because of that that you can have that concept of a double remedy. The fact that a penalty for in a customs case might be a doubling of the duty, I don't think that has the same concept. And I think even within the WTO, I would be surprised if there's not enough authority in the WTO agreements under, whether it's the customs valuation agreement or some of the other agreements there, to allow authorities in their sort of role to police imports to impose penalties in the case of non-compliance with domestic requirements. But you know, how any of those arguments, WTO type arguments, might play out in a customs case, I don't know that it's come up directly, so I couldn't really speak to it there.
Mark, we are out of time, but I want to invite the audience to join us for a reception in the Rotunda where we have appetizers and drinks, and we can get a chance to talk one-on-one with you. But before we leave, please join me again in thanking Judge Barnett.